This is cause number FM 24-00171 in the matter of the marriage of Cheryl Lynn Pinkston and Jeffrey Scott Smith, and in the interest of CBP child. We are here on the respondent Jeffrey Scott Smith's motion to recuse. Are the parties ready to proceed?
We are, Your Honor.
Yes, Your Honor.
All right. Then, Mr. Fletcher, you may proceed.
Thank you, Your Honor. I would ask the bailiff to call Tonda Curry. She's under subpoena.
Yeah.
All right, about that, Your Honor. That was me flipping paper.
Curry is an officer of the court. I do not require that you leave the evidence. Proceed.
Thank you, Your Honor. Could you state your name for the court, please?
Tonda Curry.
Ms. Curry, how are you currently employed?
I am the elected district attorney for Van Zandt County.
And you're here under subpoena, is that correct?
Yes, sir.
And may I approach the witness, Your Honor?
You may, and both parties may approach the witnesses for purposes of exhibits or impeachment without having to ask further permission.
Thank you, Your Honor.
I'm handing you what's been marked as Exhibit A. You recognize what I've handed you.
Yes, sir.
Can you identify that for the court, please?
I'm sorry.
Can you identify it for the court?
It's text messages between myself and Judge Chris Martin on the dates indicated there.
And that's obviously came from your phone. A part of that came from your phone, your cell phone. Is that correct?
Yes, sir.
Now, does that document appear to be the same document you were provided result of a subpoena on October the 4th?
Yes, sir. And let me say, I don't remember the exact date, but it is what I provided in response to the subpoena that was served on me.
Does that appear to be a true and correct copy of what you produced in response to that subpoena?
Yes, sir.
Judge, I'd offer that for.
Your Honor, we object. First, they contain hearsay messages to which Ms. Curry was not a party. Secondly, and those have not been redacted. Secondly, and this is the broader issue, the subpoena to which he referenced, that was not issued in accordance with the rules, and we were deprived completely of the opportunity to respond properly to third-party discovery. Under Rule 105.2, we were entitled to 10 days notice prior to the issuance of a discovery subpoena to Ms. Curry. That notice was not provided. Secondly, the subpoena wasn't quote unquote served. It was brought to her by Mr. Fletcher, who had $11 in tow, showed up at her office, said, here's a subpoena, cough up the documents. That's an abusive discovery process. When we get through this motion, it'll be the subject of a motion for sanctions. But the sanction we're requesting today is considering Mr. Fletcher's failure to follow proper third-party discovery rules. We request that the text messages produced in response to the improperly served and improperly provided subpoena, unnoticed to us, be excluded for purposes of this hearing.
Judge, in response, I would agree with counsel if this were regarding the case in chief, he would be correct. But with discovery subpoena has nothing to do and is obviously not admissible in our case in chief. This has to do with the recusal of the sitting district judge. And we obtained this information based on information that we'd received. We didn't know what we were going to get. Ms. Curry offered this information to us. The only reason we even gave a subpoena is because we wanted to make it more formal. We're not trying to sneak up on anybody. We're just trying to bring the facts to light.
The response, Your Honor.
Okay.
The council admits to exactly what would have been our basis for resisting this third-party discovery. And that is that it is neither relevant to the underlying matters in this case, nor reasonably calculated to lead to the discovery of admissible evidence. In light of that, that would have been a valid basis had we been provided the 10 days notice to which we were entitled. That would have been a valid basis for seeking relief from the subpoena prior to Mr. Fletcher effectively bullying Ms. Curry into providing the documents.
Judge, if I might, I can take Ms. Curry on examination about the bullying part of it if you'd like me to.
Not yet. I'm going to carry the objection at this time. I'll allow further questions. You may proceed.
Ms. Curry, was there any aggression or did I bully you in order to get this information from you the day I asked you gave you the subpoena?
Not at all.
Now, for some history for the court, Mr. Elliott and I actually met with you a couple of days before to find out if there was any information that we might need to ascertain, did we not?
Yes, we had, y'all came to my office and we had a discussion about several different things.
Informal conversation, was it not?
Correct.
Was there any confrontation or bullying or aggression shown at that time?
No, sir.
As a matter of fact, you offered voluntarily information that we ultimately subpoenaed, did you not?
In response to questions, yes, it was part of the conversation.
Right.
Yes.
So what we divulged from the conversation is what prompted us to ask for this, the records. Is that correct?
Yes, sir.
Judge, I'd pass the witness.
Cross-examination.
Yes, so you indicated to me, you and I spoke about this matter after you provided the documents to Mr. Fletcher, correct?
I'm sorry. What's your name?
Kelly Hollingsworth.
Yes, sir.
Okay. I think I mentioned to you that I was sitting in my dining room when we spoke. You remember that?
Yes, I was driving somewhere. I don't remember where now.
Okay. And you indicated to me that it was in fact Mr. Fletcher and not someone else who showed up with a subpoena, correct?
Yes, sir.
October the 4th, right?
Yes, sir.
And he had $11 with him too, correct?
I think he had $11 that time. Yeah,
That's the
I also
witness
was served for this hearing by a process server that had $11. Yeah, it was Mr. Fletcher who handed me the subpoena for these.
And so had you previously discussed with Mr. Fletcher that if he would serve you with a subpoena that you would provide him with the documents?
Yes, sir.
Okay. Did you provide us with any notice that that conversation had occurred?
No, sir.
Are you aware, ma'am, that you're entitled to be given a reasonable amount of time to respond to a subpoena? The Supreme Court said that that's about 10 days.
That I'm given 10 days?
Yes, as a third-party witness, you're entitled to reasonable notice and reasonable time to provide responses.
Yes, sir.
Okay, but you didn't do that. You just provided them immediately.
Based on our previous conversation, yes, sir.
Okay, did you have the documents already prepared when Mr. Fletcher showed up at your office?
Probably, but I don't remember for sure.
Okay, all right. Staying with my objection, Your Honor, I'll pass the witness.
Just briefly, Your Honor. Ms. Curry, there was no reason for you to assert your rights under the 10-day rule, was there?
No, sir.
Okay, you were going to voluntarily give us the information regardless, is that correct?
Yes, sir. I didn't feel like I was being. I mean, I'm an officer of a court. If I know that there's something relevant to litigation and that a person can get a subpoena, I'm gonna cooperate with it unless I feel that I have a legitimate basis not to. In this particular case, I didn't feel like I had any basis not to. I don't say that in a bad way. I didn't feel like there was a legal objection that I could pose to complying with the subpoena, so I was going to comply with the subpoena. The time frame to me didn't matter if I did it 2 days later or 10 days later or 8 days later. That was irrelevant. Best of my legal knowledge, I had no substantive way to substantive defense to complying with the subpoena. So why was I going to make it difficult? I was going to do it.
Pass the witness, Your Honor.
Ma'am, we did have a right under the, are you aware that under the rules, we had a right to object to the discovery?
No, sir, I wasn't.
Okay, were you aware that we had not been served with any prior notice of the subpoena that was served on you on October the 4th?
You told me that day on the phone that you had no notice of it, but you called me. So maybe,
I'll just represent to you, that was after the filing of the motion that attached the emails.
oh, that's okay. Okay. That makes sense.
I'll pass the witness.
Judge, also to clear up something earlier, he objected based on hearsay. We're not offering the document for the truth of the matter asserted. We're just offering the document to show that the statements were made. By District Attorney Curry and the judge.
Just offering to show the statements were made, so I'm not asking me to consider them for the truth of the matter asserted.
Well, I'm asking the court to review the text messages for what they are. They speak for themselves.
Again, I'm carrying the objection as to, I'd like to see the full document. I'm carrying the objection as to the procedure in which these documents were obtained at this time.
Thank you, Your Honor.
I have nothing further to this witness, Your Honor.
Anything further of this witness?
No, Your Honor.
May she be finally excused.
Yes, sir.
Yes, Your Honor.
May be finally excused, sir. Thank you very much. These are Exhibit A is conditionally received into evidence pending further on my.
Thank you, Your Honor.
You may call your next witness.
I have no other further witnesses, just argument, Judge.
Respondents to the motion have any witnesses?
No additional witnesses, Your Honor. Same thing, argument.
Okay. Let me just see something. All right, I'll hear arguments then.
Judges, this court is aware of rules 18A and 18B govern rules for recusal, as well as canon 3 speaks to the fact that a judge should conduct himself in such a way that perform his judicial duties without bias or prejudice, or create appearance of impropriety or impartiality. In this case, Exhibit A contains text message exchange between District Attorney Curry and the judge, as well as Bob Keltner, who's a detective of the Van Zandt County Sheriff's Department, and Judge Martin. For the history of this, Detective Keltner showed up to my client's house based on the theft of a horse worth millions of dollars. And when he appeared, both parties were there. There was documents, there was verbal questioning by the Sheriff's Department of Ms. Pinkston and my client. We're at a dispute as to who owns this horse currently up to this date. That particular time, this is months ago, Detective Keltner, in part of his official duties, was trying to ascertain who owned the horse and what had happened, because some damage had been done to my client's property and getting the horse. As a result of his investigation, Detective Keltner proceeded to file for a search warrant to obtain information from a cell phone from that particular day. He went to Judge Martin to obtain a search warrant. So
No, I do object to it. He's effectively testifying about what occurred in this situation. I don't think he called himself as a witness, and he didn't provide evidence to this effect, and he closed, Judge.
Responses to that?
I mean,
Responses to that?
I'm just trying to give the court some history as to the
Well, I
fact.
understand, but this is kind of, you know, this is more test that you're providing evidence to me of, because having read the text messages, I understand where part of this would come from, but you're providing new evidence. So are you asking to put evidence on this, or?
I will stick with the motion, Your Honor.
Okay.
Basically, the Exhibit A shows the bias and prejudice that Judge Martin has against Detective Keltner, who is a material witness in our case. He's going to testify ultimately at our trial, and evidence he presents is going to be reviewed by Judge Martin. It's obvious by the text message that Judge Martin thinks Detective Keltner's a liar. If you go look at Exhibit A, some of the things that he says, basically, Judge Keltner has lost a tremendous amount of credibility. I thought Bob had a stronger code of ethics than that. One of them is not telling the truth. You know who my money is on. This is police misconduct, plain and simple. I can't see him being able to submit another warrant to me. They should be on the same list as Katsoulis. Well, Katsoulis, for the court's information, is on a Brady list in Van Zandt County. Basically, Judge Martin also states in the text message that he talked to Detective Keltner about information about ownership of the horse that he would only have gotten in a civil proceeding, rather than just deciding what the affidavit, whether or not the affidavit was correct in the four corners of the search warrant. It's obvious from the text messages that he has a bias for Detective Keltner, which prejudices my client. This court's aware that the Duffy case sets forth the harm analysis to be considered by the court regarding recusal. Duffy versus State 428, Southwest 3rd 319, Texas Texarkana 2014. Number one, the risk of injustices to the party in the particular case. Number two, the risk that the denial of relief will produce injustice in other cases. And the risk of undermining the public's confidence in the judicial process. Basically, plain rule is whether a member of the public at large, knowing all the facts in the public domain concerning the judge's conduct, would have a reasonable doubt whether the judge is actually impartial. I think based on the text messages, if you showed that to anyone on the street, if they read those text messages, they would obviously see that Judge Martin has a serious problem with Detective Keltner and his credibility. That is a direct prejudice to my client and keeps him from getting a fair and impartial hearing. For that reason, we'd ask for Judge Martin to be recused.
Final argument? Or
Yes, Your Honor.
response?
Specifically, we do request that the motion for recusal be denied first. The basis for recusal on which they seem to be relying is that Judge Martin has a personal bias or prejudice. That's actually covered in the rule. It's 18B, sorry,
18B.
B2. Yes, I'm sorry. No, it's 18, yeah, it's 18B2, 18B2. The judge has personal bias or prejudice concerning the subject matter or a party. He doesn't have any personal bias, and there's none shown relating to either the subject matter of this case, which is a dispute over whether there's a partnership between these parties, or ownership of a horse, or any of the parties who are Jeff Smith and CHERY PINKSTON. With regard to Detective Keltner or Deputy Keltner, to the extent that his credibility has been damaged with Judge Martin, it's occurred in the context of this case. And in the context of this case is not good enough. A judge is not, I'm going to read from Rosas v. State, which is 76 Southwest 3rd, 771. A judge is not subject to recusal for bias or prejudice because of knowledge or opinions that are necessarily acquired in the course of the proceeding. A judge must form some opinions of the parties and witnesses in order to perform his or her duties. Opinions formed by the judge on the basis of facts introduced and events occurring during the proceedings do not constitute a basis for a recusal motion unless they display a deep-seated favoritism or antagonism that would make fair judgment impossible. I want to challenge another matter, Your Honor, and that matter is the claim that Deputy Keltner is a central witness in this case for them. We've had 3 evidentiary hearings on the issue of the ownership of this horse, and not one time did they ever call Deputy Keltner. He's never shown up in this case, but we've known, because they attached Deputy Keltner's probable cause affidavit for the arrest warrant, we've known since the very beginning that he was involved in this case. Everything Judge Martin has learned relating to Deputy Keltner's credibility or lack thereof has been learned in connection with matters that are the core of this litigation. If he has messed up or stepped on his credibility with Judge Martin, that's because he has lost evidentiary credibility in the course of these proceedings based on evidence that both parties have put forward. He does not, he hasn't provided anything that says that Judge Martin came into this case against Deputy Keltner. I do draw the court's attention again to the fact that Deputy Keltner is, he's not been called as a witness so far in this case, other than the attachment of his affidavit and a lot of talk about things that he's done by counsel. And he is not a party to the suit. This case is not about him. This case is about the parties to the case and about the subject matters that are at issue in the court, in the pleadings of the parties. So on those bases, we request that the motion be denied.
Response. And what about the, Mr. Fletcher, as to, because 18B subsection B2 does speak of a personal bias or prejudice concerning the subject matter or a party, not a witness.
Well, we feel that his feelings toward Detective Keltner play into the subject matter of the case.
Well, but do you agree that all this matter or these feelings that Judge Martin has expressed in the text messages arose because of this litigation and things that resolved out of this? You know, you as a former judge, me as a judge, there's times when you're in a case and you know that a witness is not being credible. Does that mean you can't, and you learn it in that case? You may learn it in a pretrial hearing and it still has to go to trial. Does that mean we're recused? Because now, hey, in my mind, this guy was not credible when he was on the witness stand. Does that mean I need to recuse myself 2 months later for the jury trial?
Well, Judge, this actually took place as a result of a search warrant that was requested that wasn't a part of this particular case. This has to do with a criminal case that has nothing to do with the civil matter. And that's Judge Martin was upset because he went to another judge to get the search warrant. And it was signed by another judge. So it's not.
Well, Judge Martin was concerned not just because of that, but because Judge Martin had rejected the search warrant.
Right.
And-
But that's a criminal case, has nothing to do with this civil case though.
Well,
And so he was upset that he.
so are you saying this search warrant, this has nothing to do with, I thought you earlier you were saying that it revolves around the theft of the horse.
Well, this all started because of the horse. Ownership of the horse is the key issue in this lawsuit. And when the horse was stolen months ago, that's what started the criminal part of this case that still exists. So our issue is the fact that his disregard or feelings about the credibility of Detective Keltner started in the criminal case, not in the civil case. I mean, he goes on to say this is police misconduct, plain and simple. They shouldn't be treated any differently than any other officer who lie or intentionally withhold important exculpatory evidence. That has to do with the criminal case. But he's clearly thinks that Detective Keltner's a liar, and Detective Keltner is going to be a witness in our case. Counsel said we didn't call him, we haven't called him. Well, there's a lot of witnesses we haven't called yet because we hadn't gotten that far down the road. So we're asking the court to recuse Judge Martin just so we can have fair hearings going forward without prejudice or bias from him. So
is your position then that if the judge learns of either, through their work, you would agree that this was not some extrajudicial function that Judge Martin, if he has this feeling, came about? It came about because of his judicial duties of signing a search warrant or reviewing a search warrant or an arrest warrant.
That's correct. That's
So
correct.
it's not extrajudicial duties. It's not because, as a lot of the cases refer to, maybe he's a member of a social club or maybe a member of a certain religion that, doesn't believe certain things. He came about this because of his work as a judge. Correct?
He did.
Again, I go back to the example I gave. What if I have an officer who testifies in one case and I realize there's a clear Brady or Morton violation and that officer did something wrong, and then 2 months later, he's a witness in another case? Am I required to recuse myself because I may have had an opinion that this officer was not credible on the witness stand? Am I subject to recusal because of that?
It's our position that his feelings regarding Detective Keltner prejudiced my client.
Okay. Anything further?
Our answer to the court's question is no, that judge would not be subject to recusal in the case described by the court. Additionally, the entire body of facts that is at issue in this case is also at issue in the underlying criminal matter that he was discussing. Third, the initial pleading that they filed in this case had a probable cause affidavit by Keltner attached to it. We just ask that the motion be denied.
Judge, briefly, the difference in this case is obviously judges are human. They harbor feelings about different things. In this particular case, he's publishing those to the public. He's telling people how he feels. He's obviously upset and mad. That's different than harboring feelings about a particular situation and keeping those to yourself. We think it's a clear bias and prejudice against our client.
Give me a few moments. Court has had an opportunity to review the motion, review the testimony, the arguments of counsel, some case law. Court finds that the motion filed on Mr. Smith's behalf is verified, that it does allege grounds under Rule 18A subsection A. Grounds for recusal basically are under Rule 18B subsection B1 and 2, that the judge's impartiality may reasonably be questioned and that the judge has a personal bias or prejudice concerning the subject matter or party. Now, based on the arguments and the evidence, there's no evidence to show that Judge Martin has a bias or prejudice against either the subject matter or a party in this case. There is argument and what can be considered evidence that Judge Martin has a bias or potential bias or prejudice as to a potential witness. So under all those circumstances, that means the judge's impartiality may reasonably be questioned, or does that bias or prejudice, does it import over to a party or the subject matter? From testament or from the testimony, from the exhibit, and from the arguments, it's clear that Judge Martin did not learn of this matter or this issue from an extrajudicial source. He learned it in the course of his actions as a district judge, being asked to sign a warrant and reviewing an affidavit, and then the matters that came from that. Further, this warrant, while it was involved in a criminal case, is tied into this case. There are several cases where judges learn of one thing in the course of their work as a district judge. There are several cases where judges may try a co-defendant, and they obviously are going to form opinions. That does not preclude them from trying the co-defendant's trial when it comes up. Further, in the case of Kelly versus State, 18 Southwest 3rd 239, that was an aggravated robbery case where a witness got done testifying, goes out in the hallway and assaults a bailiff and a sheriff's deputy, and the judge witnessed it. There was a motion to recuse, the judge saying, well, he's now biased, prejudiced against that witness for witnessing the assault. Court said, no, the judge is not recused, and the judge later on recused himself from the assault charges that resulted from that. Right now, we don't have cases, if there's any further action as to the deputy, but I'm sure that Judge Martin would not be hearing those. The law is clear that if a judge gains information through the course of his or her job on the bench or those judicial duties, that does not rise to personal bias or prejudice or question the judge's impartiality. In order for that to happen, there's even cases where the judge's highly critical remarks or disapproving or being hostile to counsel or the parties or their cases usually will not support bias or partiality challenge, although they may do so if they reveal an opinion based on extrajudicial information. That's not the case here. Under the facts and circumstances presented here, I find that public at large, knowing all the information, would not find that Judge Martin's partiality may reasonably question, knowing that the knowledge that he's gained in this case comes from his work as a judge and not from any extrajudicial function. Under the facts and circumstances of this case, the motion to recuse is denied. I will admit Exhibit A, but I'm going to order it to be sealed. I don't want this for public information. It can only be unsealed by me. regional presiding judge. And that's on motion from, a motion for the court to consider this. I will prepare an order tomorrow morning to report my ruling today, and that will be emailed to all, to the court coordinator to be e-filed for all the parties. Anything further?
Nothing further.
No, Your Honor.
Excuse me further, we are adjourned.
So great.